knows the kind of advice that I've given in that regard, finds that I believe in a most liberal interpretation of both of those. I believe that if a situation does not clearly, I mean clearly, fit into an exception, the records, the documents need to be disclosed. The records, the documents are not the municipalities, they're not the public entities, they're the public's, they're the people's. And I think as evidence of the fact that I've been able to do that is, I have no recollection, and when I say that, I don't have any recollection at all of any mandamus action ever even being threatened or being filed where I represented someone. It always got resolved, and it always was resolved, in my estimation, on the side of public disclosure. I have a record on that. It's a long and lengthy one, and I can tell you that my clients don't always agree with me on that, but my job is to keep them out of court, and I've been able to do that.
What do you think the biggest misconception is amongst, public officials, and to be fair, the press, in dealing with, open records laws?
Having been both elected official and an appointed official, being on both sides of the table, maybe I am uniquely qualified at least to tell you what my thoughts were. I think a lot of times public officials, as soon as they hear about public records requests, they're out to get me, okay? And so I think that a lot of time it's kind of like, all right, let's circle the wagons mentality, and let's find out what's in there. Is there anything that could hurt me? That kind of thing. What they many times don't understand, and I try to explain to them and I've even taken the liberal interpretation, even before the Supreme Court came down on it, that people that were like city councilmen, that were using their private cell phones and things like that, email traffic for Palms and that, if public business was being transacted on it, so those had to be disclosed by the public records. And that's before the law began to literally solidify in that area. And I know that a lot of people feel that all I have to do is I'll just communicate on something that's private, and even though it's public business, then I can keep it away from people, and that way it can't be used against me when I run for re-election, or if I decide to run for another office, things of that nature. I think from the media standpoint, I really don't know. I mean, you folks have a job to do to report what's going on, and you need access to all the information that's going on, and you should have access. I mean, I think many times public officials believe that that's their job, those are their documents that they've created as a result of the job that they're doing, and that they should be able to keep them to themselves. And that's just not the way it is. And I think we increasingly, particularly those of us that are law directors and solicitors and things like that with the smaller communities and provide legal advice, have to continue to reinforce the notion that those are the people's documents, those are the public's documents. Those are not you. You're just standing in, you're a steward, you're a trustee for the 4 years you're in office, or the 18 years you're in office, or whatever it is, but those are the public's records. But there certainly is a mindset today, I think, with particularly, I'll just say at the lowest level of government, the local government, that the media is out to get them whenever they make a special records request. And it's unfortunate, because many times I know, now not being involved in that, just providing advice, you're just trying to get the information to do a story maybe. But
your opponent was one of the only statewide office holders to release all of his emails as part of a public records request. If you're elected, say 6 months from now, and I come in and say I'd like copies of all your emails, how would you respond to that? How would you handle it?
Make a public records request, you're entitled to it. That's it. I mean, to me, it's a laydown.
So you would be able to comply with that quickly? And
well, that depends. You have to understand that I'm just getting into this email technology, but I'm getting pretty good at it. And I just, I had like 30-some emails this morning, so I don't know how many as Attorney General I would generate. I'm not putting you off. I'm just saying I'd get them to you as fast as I could, but I could see where it might take a little bit of time to make copies, or how you wanted to provide it. But yeah, we would turn them over very quickly. And when I say turn them over very quickly, we would turn them over very quickly, but let's just say that one of my emails involved a matter that was in litigation, for example, and the attorney-client privilege attached. Of course, that would fit within one of the exclusions, and I would withhold that. So there would have to be a review that would be done, but I mean, it would be a quick review. It wouldn't be regular,
your campaign has continues to draw some connections between Mark Dan and your opponent. he's quick to point out that he was one of the first Democratic state office holders to call for Mark Dan to step down when all this broke, as evidence of kind of policing his own party. You think what you've been saying in some of the ads or the campaign's been pushing is fair, and why?
I do think it's fair, and let me tell you why. And I think Mark Dan, well, I wouldn't know Mark Dan if he walked in here, but I've quoted him enough over the last 10 weeks, I feel like I know him personally. When he left office, he indicated that first of all, he was surprised that he was elected, as we all were. And secondly, he wasn't qualified to be Attorney General. And I have not one time suggested that Rich has any of the character issues that Mr. Dan may or may not have. I don't pass judgment on people. That's not my job. But I do look at what his preparation is to run that office, and